Hi, good day, everybody. Thank you for joining us for another edition of Condo Insider. I'm so pleased to have Christopher Shea Goodwin with me today. We're going to be talking on this segment about condominium documents and, some of the older condos. We got some ancient looking documents, and sometimes they're not, when we have to get them restated, they won't import into a converter that will put it into a Word document. So sometimes they have to be manually typed. So, which is a lot more expensive. You could be talking in excess of like $20,000 to have that manually typed. So we're going to talk a little bit about where these documents are kept and at the State Bureau of Conveyances. And there are some opportunities to get better looking documents. So Chris, thank you for being with me on the show today.
No problem.
I really appreciate it.
Looking forward to it.
Yeah. And I also appreciate your participation with White Council on our board of director training as well that we do every year.
I enjoy it very much. Thank you.
Okay. So seeing on the screen.
Sure. You're showing me a set of governing documents. It looks like from an older association. From the quality of these documents, I'm going to estimate these were sometimes in late 60s, early 70s. If you go up to the recording date, we can find out.
This was like in the, I think this was part of the original ones.
Okay.
Because they're referencing 1955.
Yes, those would be territorial law, not state law.
Yeah. So these are really ancient, and this is what the documents what they look like on some of those older condos. And I know some owners have kind of like said, I paid how many thousands of dollars and I get a document that looks like this. Can't we get a cleaner cut document? Things like that. And the plus two, when a board wants to restate their documents, having a document like this is going to be, it might hinder being able to import them into a Word document so that the restatement can happen. Because if an attorney can't import it, it's going to be so costly to have them retyped, right?
Yeah, let's talk about the procedure for a minute. So first off, if you want to restate your documents, restating your documents is a method that's available under the current condominium statute 514B, whereby without ownership approval, a condominium association can restate its documents to update them in compliance with current law. The condominium law changes every couple years and substantially changes maybe every 10 years or so. Well, the governing documents are not always amended or restated, or those new laws are not always put into the governing documents. So the law provides a method, and the method is restatement of the documents. And basically, the documents are the current documents, whether they be amended or the original declaration and bylaws, are submitted to an attorney. And an attorney takes those documents, and as you pointed out, Raylene, in your opening, usually the law firm, we take the documents and we scan them, utilizing a PDF program to convert the documents into Word or another word processing program, most commonly Word, so that the documents can easily be updated and edited so that we can incorporate the new statutory language into them, basically as a word processing method. Of course, the attorney has to review the documents to make sure that the laws are all correctly stated within the documents, and has to enter citations to the new law in the form of footnotes in the new document, in the restated documents. The procedure with respect to the legal matter is basically charged on an hourly basis, whether it's done by an attorney and or a paralegal in our law firm. But the administrative procedure is converting the documents into a format that can be easily edited and modified. And that would be, of course, taking the document as clean as possible, converting it to a PDF, and then again converting it to a Word document normally. If it's a clean document, today's software and scanners can usually do a very, very nice job where you can get up to a 95% effective rate, whereby only 5% of the documents are error, or sometimes even less. Conversely, if the quality of the document, such as this one, is low or lower, you're going to get an error rate of 50% or more, which means that it's going to be a lot of gobbledygook, or I hate to use that technical term, or a lot of characters on the scan document, they're not going to be legible. So that means that our staff is either going to have to spend a large amount of time reviewing the scan document and making sure that all of the errors are corrected, or perhaps it might be even more cost effective for the staff simply to retype the document, and we would charge that either on an hourly basis or a page basis, depending on what we're doing. But as you correctly pointed out in your opening, that would be very expensive for our clients. Normally, it's best that we have a clean document, we can convert it, and it's substantially less expensive for the client if we have a clean document that we can scan and convert it to a Word document and restate it at that time. That's normally the procedure.
Right. So in my search to get a cleaner copy, I actually, you can do this online, right? Go to Bureau of Conveyances, you look up your condo, you should be able to find it there. There's a kind of like a search. But for whatever reason with mine, I kept having glitches. I even called. They're very limited in how much they can help you over the phone. And plus you can tell that they're trying to help other people that are there in the office as well. So I actually went down there to the Bureau of Conveyances, and they have computers there. And I had the same glitch. And so there was only one person there in the office. And she was also trying to help another people that were already there, plus answer the phone. So I said, see, I'm getting the same error. And she kind of fiddled with it, and she was kind of stuck. And I know she went and called somebody, and she told me to do this. And I was able to get it and look for the document. And I actually was able to get cleaner copies, a lot cleaner copies, way cleaner than this. You could tell this one came from a microfilm, but that one looked like it was, yeah, well, I looked at it, I go, oh, this is going to import easy. Because sometimes you can tell after we've been doing it for a while. You can tell that it's going to import easy. This one, like Chris said, it's going to be a nightmare, because then you have to go back and really have the eyes to edit to make sure it captured all the words correctly. Because like you can see some of them, you can't even see some of the words. You can tell what it is, but it's not going to import very well. So that would be one of the reasons. And when you go down to the bureau, you have to pay per page. It's not just come with a lot of, I think, quarters and dimes. It's not a whole lot, but you have to have cash. So I don't think they take, if I remember right, they didn't take checks, or maybe I didn't have checks at the time. Definitely does not do anything payment online. They don't do that. But it's still a manual payment system. But it's worth the money if you need to get a clean copy to go down there. And Chris, so when you talk about the amount of times or the frequency of restating documents, it's not something you do every year or every 5 years. I mean, you can do it because still 514B they still have to rely on 514B, right?
Right. Any of our condominium association documents are pre 514B, and let's explain what that means to your audience. Chapter 514B is the current condominium statute. Just so everybody aware, it's called the Condominium Property Act. And the original Condominium Property Act was actually many, many years ago, 514. Then it became 514A. And then in 2006, I believe, it became 514B. 514A was eventually sunsetted, which means it no longer exists. So condominium association documents which reference 514A or earlier normally should be restated. And as you pointed out, Raylene, restatement of condominium documents usually is not warranted unless there has been a substantial and material change in the condominium law from the time the declaration and the bylaws were adopted. Obviously, 514B was a huge change in Hawaii condominium law. And once 514A was sunsetted, i.e. it no longer exists, then those documents which only relied upon or only cite to 514A or were all pre-514B adoption, those documents should be restated. And again, as you correctly point out, that's usually a once every decade or more procedure. You don't do that every year. You don't do that every 5 years. You do it as needed when there's a substantial and material change in the condominium law that materially changes your documents.
Right. And every year there's not a whole lot of big changes. I want to say that, I mean, every 10 years could be good. But if you have some years where there's like a lot, but that's kind of rare, right? I mean, you've been in way
Yeah,
long enough.
since the adoption of 514B, if you had condominium association documents that were formed when 514B was in existence and 514B was the law of the land at that time, there would be no reason, in my opinion, to restate your documents at this time, as long as they were formed in accordance with 514B. If you've still got 514A documents and they haven't been restated, it's probably time to restate your documents or well past the time.
So like this one references chapter 17 GA,
Which
is
I
from
will tell
1955.
everyone.
But I think
I've never used that statute, and that looks like that's pre-statute, everybody, because it says it's a 1955 statute. That was before I was born, by the way. But with that said, chapter 17 GA was apparently the condominium statute at that time in 1955. If you still had a set of documents from that far back, obviously they need to be restated.
So this one, I was just really looking for an old one, and I was looking for one that looked really crummy. So I know this particular condo has had theirs restated, but I think they have to. I mean, but that was way back in the 90s, I think. So they're due for an update.
Probably, if they were in the 1990s, they are, because that would be a pre-514B project document.
Yeah. And but plus too, even if they're as ancient, their bylaws are as ancient as they are, they still would rely to 514B for the statutes, even if it's not in their bylaws, right?
Correct. But there's a lot of things in 514B that may be included in the declaration and bylaws that should be included. And that's why you want to cite them, and you want to restate the documents so those are cited as part of your governing documents, included as part of your governing documents. So that's why the restatement, particularly for pre-514B governing documents, those should be restated so they're updated to the current law, which is 514B. Now, when you do a restatement, remember, everybody who's listening today, the restatement will actually have a series of footnotes or endnotes to explain or cite to the statute upon which the restated language is based. In other words, this section is restated pursuant to 514B 113, for example. It will tell you in the footnote or the endnote exactly the basis for why this section was restated. That's very important. Yeah,
because your typical owner may not understand. They're going to get this one document, and we're like, no, it's in 514B, and they're like, what? I thought we have to rely on the bylaws. You're supposed to rely on bylaws plus whatever this the current statute that like a 514. Well, in this case, it's 514B.
Right.
So kind of want to make that clear to everybody that you have to look not only governing documents, but you also have to look at the condo statute. If you're in a condo, it's 514B. If you're in an HOA,
421J, right?
Yeah. Co-ops are 421I, but their statutes only like that big. They're not that big. So we kind of want to made it clear about these restatement of documents. Plus two, if they're as ancient as this one is, or that we still have to rely on both governing documents and 514B whenever we're looking for something. And if I remember correctly, the boards can also put monies away for restatement through their reserves.
That can be a reserve item. That's properly a reserve item.
Because, I mean, if you don't need, say you put it in for a reserve for every 10 years, 10 years comes, and, maybe not in any insignificant change, but you have the need for that money on another item that's coming up, it could be done that way, because you still have to. You
could basically do a deferral to say that component is not yet due for replacement. And in this case, that would be repair or replacement of your governing documents. In this case, restatement of your governing documents. Since it's not due for restatement or restatement's not necessary, you could defer that to a later date. That's correct.
So restatement does it take a vote requirement?
No, restatement can be done by action of the board.
Okay. It's only if we make changes, bylaw changes, that would require ownership vote.
It's very important. This is not an amendment of the governing documents. This is a restatement of governing documents. So let's talk about this for just a minute. An amendment is generally something that must be approved by the ownership. Very, very important. Normally 67%, but not always. The declaration of bylaws could have a higher percentage. With that said, a restatement does not require owner approval. It simply requires a board resolution restating the documents and the restatement is only as necessary to bring the documents into compliance with current law, no more. And that does not require ownership approval.
Right. But if they're creating something new, that would
Different
be an
matter, completely different matter. That would be an amendment.
Yeah. So there's a difference. Restatement and amendment. They're two different terms. Restatement is just redoing the document to bring it up to current.
Current law.
Current law. An amendment is that they're adding or deleting something.
It's any change to the bylaws, any change to the declaration, other than a restatement, would be an amendment that would require ownership approval, unless the governing documents provide something to the contrary that says you can do this without ownership approval. But again, that would be very, very rare. Normally, any amendment to the declaration or bylaws would require 67% or more ownership approval, as set forth in the declaration or the bylaws.
The other point I wanted to make is that not all bylaws and declarations are created equal. You have 514B, which is kind of like your basic, that applies to everybody. But then within the declarations and bylaws might be something that applies only to that particular condo. Like some bylaws they don't have board meetings. They call them special meetings, and they might have different timeline requirements for that, or even annual meetings. How the percent of votes will dictate who becomes president, vice president, something like that, right?
Yes, that's true.
So that's why when you're saying, well, my friend's condo, they do it this way. And I'm like, if it's in their bylaws, they're not all created equal. So one condo might differ from another condo. So you can't just, take somebody else's example, your friend's example, that they do their annual meetings this way, but it could be because, and they're different than yours, they're completely different than yours, but more than likely it's because their bylaws require them to have it done in a certain manner.
Yes, for example, they can't conflict with 514B, let's say, for example, for a meeting notice requirement. But on the other hand, for example, what if they say that for an annual meeting, that instead of 14 days prior written notice, that owners are entitled to 21 or 30 days notice before an annual meeting? That would be permissible if it's set forth in the bylaws, even though that is longer than the notice requirement set forth in 514B. Conversely, the notice requirement could not conflict with 514B, so it couldn't be less than the 14-day prior notice for an association meeting, notice of an association meeting as mandated in 514B. So the difference is that it can certainly be in addition to or supplement a requirement in 514B, but it cannot conflict with 514B. So you're correct, Raylene. If it conflicts with 514B, 514B would control. But if it supplements or adds and does not conflict with 514B, then the bylaws provision would control.
Yeah, and I think I see that in some of the older ones. I think, in your experience, are the New York Kakaako, are they still pretty much basically 514B and maybe not that many, added?
That is depends, because there are several attorneys who were not traditionally developer attorneys who drafted governing documents for condominium associations in Kakaako and other new condominium associations on the island. And they have provisions that, frankly, were not historically seen in documents prepared by firms that were historically developer attorneys and had their form documents. For example, I do have condominium associations in Kakaako, at least one in particular, that does require notice of the annual meeting be in excess of 14 days. They have a 30-day requirement. That is unusual. So it is important that even though you are at a relatively new condominium association, that the board is familiar with, for example, meeting requirements to the extent they may be longer or greater than what's set forth in 514B. Good question, Ray.
Yeah, I can imagine maybe possibly, and I don't know for sure because I don't know what but I would imagine some of those developers like Kakaako, Howard Hughes, maybe they had an attorney that was a California attorney, or
that's possible. That has happened. I have an out-of-state attorney who did a complete set of documents for a very large association on the island, and it did require some substantial revisions.
Yeah, so they're more familiar with whatever that state is, so they kind of put the provisions into that versus following 514B. So that's where some of the differences could be. It's at the whim of whoever wrote them originally. Right.
I would not use the word whim, but certainly based on your experience.
The discretion of. Okay. So is there any other thing that you want to cover with condominium documents? Because I know you always say subject to governing documents.
It is subject to the governing documents and or 514B. I do want owners to realize that who are listening to today's presentation, that your first source for getting a copy of your condominium association documents should be the managing agent. The managing agent under Hawaii law is required to provide all owners a copy of the governing documents at their request. You should make that request directly through the managing agent. And if you get a copy of the governing documents, as you point out, Raylene, that is not legible or is questionably legible, then your next step is to perhaps seek a copy through the Bureau of Conveyances. And that is, as you pointed out in your experience, a somewhat more cumbersome process to do. You can do it online, but you'll find out when you do it online, you may not necessarily receive a better copy than what was provided to you by the managing agent. And you often have to go down. Unfortunately, there is a wait at the Bureau of Conveyances for someone to assist you and see if you can acquire a better copy on your own. I'm not saying that you're always going to be able to do so, but we do have to utilize the Bureau of Conveyances directly on occasion in order to obtain a legible copy of the governing documents. And I would say that happens, maybe once a year at the most. We don't see it that often.
Right. Yeah. It's a rare kind of a thing. And then also with respect to the governing documents, we really, I know Hawaii Council, we really encourage everybody to put them onto their website because they need to be easily accessible to people that need them. I know sometimes for some reason, the solar companies might need to access the governing documents, especially the CCNRs,
yes,
because they want to follow the restrictions. Yes. And they also look at the governing documents to make sure that they're in compliance and stuff like that. So you kind of really want to make them easily accessible to the people that need them. It's not like there's private, I don't want to say that there's confidential information in those documents that would prevent someone or would, a condo would say, no, we don't want them to see it because it has this in it. I'm not sure if that would really apply, but there's been a lot of issues going on with being easily accessible to these documents, especially your CCNRs and house rules. I mean, I know I've said this a million times. I mean, I kind of get some people calling about, well, they're going to charge us for the house rules. I'm like, why? You want them to comply, make it easy. Now they don't have an excuse to not comply. You gave them the house rules and you gave it to them for free. And especially the CCNRs, you want to make them easily accessible so that to me, there's no excuse why they can't follow it, is my rule.
The governing documents, at least the declaration of bylaws, are public documents because they're recorded with the Bureau of Conveyances and or land court. So there would be no reason not to produce them to a requesting third party.
Yeah. So it's not just owners that need it, it's other providers that need it, vendors, especially for your townhouses, single family, your HOAs. It holds up and it complicates the process. Because I know at DPP, they called me about it. And I'm like, yeah, we're really encouraging people to put it online because they were getting frustrated. I guess there's a solar task force, I want to say, and they work heavily with the DPP, especially when they had that backlog of permits. They were trying to figure out how to make it easier. So they did do some changes in regards to solar installations when you're in your HOAs that were advantageous for the companies to get their installations done. So anything else you wanted to tell our audience, Chris?
No, I think we've covered this issue today pretty thoroughly.
Okay. So thank you for joining us today. We hope you've got the information you need regarding your condominium documents. Hope we covered everything. I'm pretty sure we did. But if you still have questions, you can always reach out to Hawaii Council as well. So thank you, and thank you for joining us. And we hope you will check to our YouTube channel for other topics that we have on Condo Insider. Thank you, Chris.
Thank you, Raylene.